Good morning, ladies and gentlemen. The expectation level that was raised is immense. Yeah, I certainly agree with him that what we are talking about here is most important, certainly to me. Whether it's as important for you, we will see. So this topic I'm going to talk about is pharma patent litigation in BRIC countries, in emerging markets, and that is becoming an increasingly important topic for the pharmaceutical industry like ours, because these markets become more and more important. I will focus in the end on India, because we are here in India and you might actually be interested in also getting a perspective from the outside. But I apologize already now that whatever I say there is, of course, is not the sophisticated approach that a local attorney would actually choose, but it's a broad brush approach, looking from a helicopter at this topic. So the litigation we are doing, especially in those emerging markets, is mainly between originators, we as the originators and generics. Yeah, it's rarely happening that we actually do originator type litigation here. But I thought it would actually be useful to take a step back and actually look again at our business. Here, this is a sketch of how usually the cost profit develops over time for a successful drug. And what you see is, at the beginning, we spend a lot of money, it takes a long time, and even after launch, we still have to spend an immense amount of money to actually get the drug to the market and make the physicians familiar with this drug. If we are lucky, we make, after that, a lot of money, and then you see this patent cliff in the end, and that's when the patent exclusivity expires, usually. And this graph is a sketch, so be mindful that it will look different for each and every drug. It will probably look different for different markets, for different countries, but I think it gets the general idea across. And this patent cliff, of course, is caused by the generics coming onto the market. But you saw those numbers or this graph for the successful drug. We have to support with that all the R&D investments also in the not successful drugs. And there are many of them. The attrition rate is very high. So the take-home message from here is, and you knew that already, I guess, that the research and development for pharmaceuticals is lengthy, costs a lot of money, and is very risky. So when you look at the key stakeholders in this game, the healthcare systems, the originators and generics, there's an interdependency between these stakeholders. All need each other. So the healthcare system needs the originators so that they actually come with new drugs, new therapies that helps the patients. In the end, after patent exclusivity, the generics are needed in order to actually relieve capital in the healthcare system so that the more expensive new drugs can be paid for. And that needs to be done by cheaper drugs. But the generics also shouldn't kill the goose that lays the golden eggs. Because without new drugs from the originators, there's no real business model for the generics. So let's go to the BRIC countries. In what you can say in general about Brazil, Russia, India, China, in principle about all those all emerging markets is, as a rule, you have overburdened patent offices. Usually very long times until you actually get a patent. When you look, for example, at Brazil, on average, a pharmaceutical patent takes 14 years until it's granted. So it's an immense time when you consider that we have a 20-year patent term. You have an insufficient number of experienced patent examiners, which is maybe not surprising because many of these countries actually have established real patent prosecution not such a long time ago. Also, especially in the first instance courts. The first instance courts are important for us because they are the first gatekeeper against the generic. And we need these decisions early. They are very often have limited technical and patent experience. Yeah? Many of these judges see a patent for the first time when they are actually exposed to such a court proceeding. There's little national case law to go by for the judges, which also makes it difficult. Unfortunately, very often, the courts don't look left and right. They basically try to reinvent the wheel. When matters have been decided elsewhere, it would be great, if they actually took that into consideration. And what makes it difficult for us to actually enforce our patents is that it's very often difficult to actually find out that a generic will come to the market. So when I looked at this 2 years ago, India, in 2014, what was the situation at that time? What, on the positive side, I would say, yes, preliminary injunctions, and I apologize also here. I know that you used the term interim injunctions, but the PIs is more easily abbreviated, and it's the term that is very often used outside. So PIs were granted. You could get PIs to some extent. However, there was suddenly a new interpretation of the Section 8 requirement. That's the disclosure requirement. Suddenly, something for me at least very surprising happened. Suddenly you were supposed to actually submit information about patent applications not related to this patent family, but maybe something about later filed patents, which from our perspective, or from my perspective, didn't really make a lot of sense. The infamous Section 3D was interpreted in a Novartis case as enhanced therapeutic efficacy. 3D is about polymorphs, about solid forms, about derivatives, prodrugs, whatever. Then a compulsory license was granted in a non-emergency situation when we actually thought, okay, compulsory licenses, yes, exists, they should be allowed, but in principle only when you have something like a pandemic situation, HIV or who knows what. And there was something creative done by the defendants, something like I call it 3D squeeze. So a non-infringement argument of something where you would have thought before, yes, that is clearly infringed, by a later filed patent on an incremental innovation. So let me go through those various aspects and tell you what I see has happened since then. So let's start with Section 3D. You know the Novartis decision, that was about a polymorph, a better polymorph, and that was rejected as not patentable due to enhancement, because no enhancement of therapeutic efficacy was shown according to the court, and therefore, and no enhancement meant also increased oral bioavailability, for example, was not considered as sufficient. There has been a whole row of decisions, and I look here only at the pre-grant opposition level. There was a whole range of patent applications rejected or revoked, one has to say rejected here, because of 3D. There's almost no invalidity tag nowadays, which doesn't include a 3D challenge. And you will see it was about crystal forms, it was extended release formulations, about salts, all were considered not to have demonstrated enhanced therapeutic efficacy. Now they also look at compound patents and raise the 3D challenge. The term derivative appears in 3D, in the Gilead case, prodrugs, like in the Roche case. All were considered to violate Section 3D. So this one was maybe the most striking for me, infringement. When the queen or the king of our patents is usually the compound patent. And the compound patent usually deals in our field with a chemical formula showing some structural configuration. And it's usually not that difficult to actually demonstrate, a structure that an infringer brings onto the market is actually covered by that structure. But now an interesting concept was introduced by the defendants. They said, okay, if there has been a later on incremental innovation on that, for example, on a new polymorph or a new salt or who knows what, that actually punches a hole into your protection. Yeah, so you, it cannot, it's an invention, cannot have been enabled. Your original compound patent must be insufficient with respect to that. That was a very, very striking interpretation of the situation, which was really dumbfounding for anybody used to the European or the US jurisdictions. So this first example, which I will look at in a little bit more detail, dealt with a diabetic drug. And so the compound patent claimed sitagliptin and all pharmaceutical salts. That's the usual. Yeah, it was a Markov formula, a chemical formula, and it was directed, clearly covered sitagliptin as a structure and pharmaceutically acceptable salts. And it disclosed as a species only the hydrochloride salt. Then later on it was found during development, as is very usual. Yeah? You have to remember that these compound patents are filed early on in research. And in research, the only thing you are interested in is, does it actually work on your biological target? And there it doesn't really make a difference what kind of salt or so you have, but later in development can make a very important difference, yeah? Whether you have a better drug or not such a good drug. And so it was shown that, or they found that the hydrochloride is less hygroscopic, and is hygroscopic, and therefore it would be better to have a different salt, and they chose the phosphate salt. And they filed a patent on it, got it granted in many countries, and then it was abandoned in India because of the 3D requirement. And so what happened? Yeah, in the Delhi High Court, a PI was denied. And the reason for that is you need, as you know, in the past, when you requested for a PI, you only had to have a credible argument regarding invalidity or non-infringement in order to avoid a PI. And that was done here. So the defendants were successful to actually raise doubts on infringement because of this later filed salt patent that seemed to punch a hole into the protection of the compound claim. This was reversed by the Delhi High Court Division Bench, and this is actually a decision I really recommend reading. It's good reading, yeah, because it really nicely explains the issue and actually explains why such patents should be infringed. And so it clearly said acts happening after the filing of this patent, of the first compound patent, are not really important. Yeah, what is important is that the compound formula, this Markov formula, covers the active therapeutic ingredient. Yeah, because that's what this invention is about. Actually, the interaction with the biological target, that is a certain enzyme inhibitor. In this case, that was the free base. And that was the real invention. The salt was only considered as a carrier that improves then later on the suitability of this compound as a drug. But really for the biological interaction is not that important. And that was fortunately then in the case on the merits, that was confirmed, and a permanent injunction was granted. The patent was held valid and infringed. So another case was a Rush versus Zippler-Alatinib polymorph case. And I go through that very quickly because it's very similar circumstances. Here we are not talking about a salt, but about polymorphs. So Alatinib is a cancer drug. And in the original patent, the species disclosed was a mixture. Yeah, as is very often the case in research, you don't really pay attention to these aspects. They're not really important. And then it was later found in development, okay, it's actually better to take the polymorph B because that is the thermodynamically stable one. Again, granted in many countries, abandoned in India because of Section 3D. So what happened? Already early on in 2008, PI was denied, exactly for those reasons that I mentioned before for the Merck case. Continued at the division bench. And then in the case on the merits, also the injunction was denied, yeah, for that reason. And only now, recently, so it's a very recent decision in 2015, the division bench of the Delhi High Court in the case on the trials, they did not issue an injunction. And that was unfortunate in this case because the patent was close to expiry, only a few months left. But they said, okay, they should be entitled to damages. So all in all, a very positive trend. PIs continue to be granted. Actually, it's possible, as demonstrated, for example, in Merck's sitagliptin case, to actually keep the generics off the market. Also, ex parte PIs are granted, and this is just a selection of the various decisions there. Compulsory license as an issue. You remember the Bayer Natco case, where the first compulsory license was actually granted. Later on, in the BDR versus BMS case regarding Sprycel, a compulsory license was rejected. So that was comforting. The reason for that was there were no good faith negotiations. You might know that the law actually foresees that you need to negotiate a voluntary license for 6 months or so before you can actually ask for a compulsory license. And this trend was confirmed in this Lee versus AstraZeneca case on saxagliptin, where also the compulsory license was rejected. And there it was good to see that public availability or perceived lack does not automatically lead to a not abiding by this requirement of the compulsory license section. And also affordable price and non-working in India. Section 8, disclosure. In this previously mentioned Roche versus Cipla case, also one other reason was non-compliance with disclosure requirement makes validity doubtful. So this credible argument of invalidity was raised, and therefore the PI denied. You know the Chemtura decision, similar reasoning. And then fortunately Beal versus Phillips came up, and there they said, okay, there's a discretion element in the Patent Act. There's no automatic revocation of the patent due to non-compliance. And that at least raised the sword dangling over the patentee's head a little bit higher. It's a little bit further away. I wouldn't say that the risk is completely eliminated. So how does India present itself today? PIs are obtainable, good sign. No further compulsory licenses granted. That is also very comforting. 3D remains a big hurdle. I personally have my opinion about 3D. I think it's not good for the Indian pharmaceutical industry, but that's how it is, the law right now. There's increasing technical understanding, as demonstrated, for example, in the Merck versus Glenmark decision by the courts. And the courts use the discretion, for example, as shown in Section 8. And they look left and right. I was quite amazed to see how they actually cite foreign decisions and bring them into the reasoning of their decisions. So, to wrap up, I think it's good that when you have patent officers and judges actually cooperating on an international level. I think there have to be standards for internationally accepted standards for patentability, both for patent examination and enforcement, in order to avoid squeeze situations from one country to the next. I'm very much in favor of a high quality and efficient patent examination, because I think that leads to stronger patents. And I know that that doesn't exist in India, this presumption of validity, but I think there should be a presumption of validity because it has undergone this examination process. And all that would lead to more legal certainty, and therefore also, which is important for us, to global business certainty, and therefore also to a higher incentive for investment in research and development, so that we can come up and actually invest this capital in new innovative therapies. Thank you very much.